So the Supreme Court just issued a new 6-3 decision in a case that is going to have major implications for Second Amendment cases going forward. So let's break down what just happened in this new Supreme Court case. Now, real quick, if you're watching this channel, then obviously it's safe to say that you care about the Second Amendment and your rights. Now, here's the thing, even law-abiding gun owners are ending up in jail because they make a bunch of critical mistakes. And those are mistakes that you don't even realize that you're making or that you don't understand that they're illegal. So I put together a free resource called the Legal Survival Guide. It's aimed to help you guys avoid all of those traps that maybe you could fall in. It takes about 2 minutes to read. It's just a simple PDF, and it really could save you years behind bars. I made it to help you guys, again, completely free to download using the link down below. It's just something that I wanted to provide you guys for free so that you can have it in your phone or maybe print it out. And there's a little card also in there that you can put in your wallet to give you additional resources to help you in situations. Obviously, not meant to be legal advice. I'm not your attorney. This isn't an attorney-client relationship, but I wanted to provide you guys some free resources to prevent you falling in some bad situations. Again, if you're interested, click the links down below. It's completely free to do. All you have to do is enter your email to get that free PDF. As I mentioned in the intro, we received a significant 6-3 decision by the Supreme Court in a controversial case. This ruling by the Supreme Court has broad-reaching implications, and it will directly impact Second Amendment cases going forward. This ruling and this decision by the Supreme Court outlined that universal, nationwide preliminary injunctions are no longer legal and valid, and that lower courts must now actually limit the scope of relief that they grant in all cases, including Second Amendment cases going forward. The case and opinion we're going to be breaking down in this video is called Trump versus the Case of Ink challenge. And again, although this case does not directly deal with a Second Amendment issue, it's not directly a two-way case, it's still going to directly impact two-way challenges going forward because this type of preliminary injunction relief is something that we've seen happen before in a lot of two-way cases. Also interesting that I want to note in this opinion is that it was authored by Justice Barrett, and also in this opinion, she calls out Justice Jackson. And there's a lot of discussion about, what actually Justice Jackson said in her dissent. And in a very interesting way, in a very professional and legalese way, Justice Barrett essentially calls Justice Jackson dumb in this opinion. So it's very interesting to see how this developed. Now, in this 6-3 decision, you have the Supreme Court here rule that federal courts lack the authority to issue universal or nationwide injunctions. The majority opinion was authored by Justice Barrett, and she held that such broad injunctions which prevent the implementation of a law or policy against anyone, not just the specific named plaintiffs in this specific case, likely exceeds the powers granted to federal courts under the Judiciary Act of 1789. This decision significantly limits the ability of lower federal courts to halt the application of federal laws or executive actions across the entire country. So this limits the ability to grant nationwide or universal preliminary injunctions. The case arose from challenges to President Trump's executive order on birthright citizenship. However, it's important to note that the court's ruling here was procedural in nature and did not address the actual merits of the citizenship issue, but it still has far-reaching implications for how federal courts actually handle these challenges and these type of government actions going forward and what type of relief can actually be granted by a lower court. Now, like I mentioned, the majority opinion was authored by Justice Barrett, and the three dissenting opinions were Sotomayor, Kagan, and Jackson. Now, in the majority opinion, they relied heavily on history and tradition of the founding of our nation to determine whether or not universal, nationwide preliminary injunctions are actually valid. Now, after performing the historical analysis, the majority actually found that this type of nationwide universal relief is not consistent with the history and tradition of our nation. Justice Barrett, in the majority opinion, stated that under our well-established precedent, the equitable relief available in the federal courts is that traditionally accorded by courts of equity at the time of our founding. Nothing like a universal injunction was available at the founding, or for that matter, for more than a century thereafter. Thus, under the Judiciary Act, federal courts lack authority to issue those types of relief. Now, the three main things to take away from this ruling is first, this limits the scope of relief that can be granted by lower courts. The court emphasized that injunctions should only actually provide relief to the specific parties in a case, not to all individuals nationwide who may potentially be affected by a specific law or executive action. The second thing is that they focused heavily on historical precedent. We've seen this develop in the two-way context with Bruin, where the Supreme Court focused heavily on text, history, and tradition. And here you kind of have this history and tradition analysis also play into a review of the Judiciary Act of 1789. Now, the third thing to take from this decision, and kind of the last thing, is that it has implications for a lot of litigation going forward and also two-way litigation going forward. The decision may encourage more kind of class action lawsuits or other legal strategies for parties to seek broader relief from the government actions, and they might do that by, challenging these types of maybe state bans or state two-way restrictions or ATF actions by filing lawsuits through organizations and trying to get relief for membership organizations. They could also file, in the name of a state. So maybe one state against, the ATF and try to get relief for the entire state. So you would try to structure this way in kind of a class action way where you're going to get relief for a broader class of individuals and plaintiffs for an entire state or for an entire organization or memberships or maybe for a company and their customers. And you would try to increase the relief that way, but just trying to get blanket universal nationwide injunctions is no longer permissible. Now, turning to the interesting statements made by Justice Barrett against Justice Jackson and her opinion and in the whole dissent that Justice Jackson presented in this case, you had Justice Barrett state that the principal dissent focuses on the conventional legal terrain like the Judiciary Act of 1789 and are cases on equity. Justice Jackson, however, chooses a startling line of attack that is tethered neither to the sources nor, frankly, to any doctrine whatsoever, waving away attention to the limits on judicial power as a mind-numbingly technical query. She offers a vision of the judicial role that would make even the most ardent defender of judicial supremacy actually blush. In layman's term, what Justice Barrett is actually saying is that at least the other dissenters here, Kagan and Sotomayor, actually rooted their dissent in legal arguments, but Justice Jackson is kind of going off the rails, and not even the liberals on the court agree with what she's saying, and that it's just so clearly wrong that they don't even want to address it. Barrett went on to state that we will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. We observe only this: Justice Jackson decries an imperial executive while embracing an imperial judiciary. No one disputes that the executive has a duty to follow the law, but the judiciary does not have an unbridled authority to enforce this obligation. Because analyzing the governing statute involves boring legalese, according to Justice Jackson, she seeks to answer what she believes is a far more basic question of enormous practical significance. May a federal court in the United States of America order the executive to follow the law? In other words, it is unnecessary to consider whether Congress has constrained the judiciary. What matters is how the judiciary may constrain the executive. Justice Jackson would do well to heed her own warning. Everyone from the president on down is bound by law. That goes for judges too. So in the most kind of professional legalese way, Justice Barrett just called Justice Jackson actually kind of dumb, and she calls her out for making a horrible dissent, that it's not grounded in law at all, that she's gone off the rails, that not even the own, liberals on the court, the other liberals, they don't agree with her. At least their dissents were grounded in legal arguments, but hers is off the rail and they don't even know what she's talking about, and that she's adding really nothing of value to this opinion. So you may be asking, what is the big takeaway for the pro-2A movement based on this case going forward? Well, nationwide or universal preliminary injunctions are now off the table going forward. Relief is going to be directed by the Supreme Court to be more limited to just the parties in the case. So you have to limit the scope of relief that you're going to request, and then the court has to limit the scope of relief that they grant in these type of preliminary injunction situations or emergency situations like TROs. That means that you will probably see more states and 2A organizations actually be named as plaintiffs and parties in these cases, along with some individuals. That will be done to kind of broaden the scope of relief beyond just 1 or 2 individuals if you win a case. But that does not mean that maybe if you got a merits win against something like the APA or the ATF put in place something like the pistol brace rule through executive actions and new rules, and under the APA, That doesn't mean if you got to win there on the merits that you cannot get a nationwide vacatur. So a vacatur is a little bit more of a final resolution. So we would have to see how that would play out and how that would impact some 2A cases going forward. So this is a sleeper decision that not many people are talking about, but it's going to directly impact 2A cases going forward. It's going to be interesting to see how this rolls out and how it's applied to some of these cases going forward. If you have any questions, go ahead and comment down below, and I will try to answer to the best of my ability. If you want to support the channel, one of the best ways to do that is to subscribe to the channel. Also, you can check out my website, armscholar.com, where we have a free legal guide. All you have to do to get that free PDF is to put in your email, and then we'll send you the PDF. And then also over there, we have some daily deals where you can check out those to save some money. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.